Look at this.
Yeah, we can't do this. Yes, out of 10.
They have new materials now. Well, most of the original affidavits.
Yes, those are.
The affidavits haven't been admitted to evidence yet. When they're offered, I'd like to, I'd like a chance to object to them.
Have you seen this?
I have seen them.
Okay. I think I said back on the record, we're reading
Okay, I've tendered to the board original affidavits that I've asked to be marked as candidates of Group Exhibit 1. And I've moved that these be admitted and considered by the board in accordance with its rules and practices concerning the admission of documentary evidence, including affidavits.
The objection?
Yes, we object, the objector objects to the admission of these affidavits. Two groups of objections. The first is to the affidavits as a whole. I'm not objecting to affidavits in lieu of live testimony, but section 10-4 of the election code says, a petition when presented or filed shall not be withdrawn, altered, or added to. There is nothing in the petition as filed that states that these circulators' affidavits were sworn to. And it is simply adding a missing element to allow that to be filed now, weeks after the time for filing petitions has been completed. So no affidavits should be allowed on this point. Now, I will give my other ground, and then I'll say one more thing. The other ground is that several of the affidavits do not stand for the proposition that there was an oath taken. The affidavit of Olga Deitch does not state anywhere that Robert Flannery, aka Bob Flannery, signed the circulator certificate under oath. There's no reference to an oath, there's no reference to under oath. It simply doesn't say anything about being under oath. This is the affidavit of Olga Deitch, D-A-Y-T-C-H.
It would be the last one in your packet.
They're not separated, so.
Okay, but that objection doesn't go to the, is offering it as an exhibit, but rather the contents of the affidavit itself.
Yes, you're right.
Unless you're moving to strike it for some reason, but I'm not hearing that.
Well, the first question is, will the affidavits be admitted at all? And I believe they should not be, because they're an effort to add to the petition as filed. You're right, this objection relates to this particular affidavit as not casting any light on whether or not there was an oath.
Okay, so maybe.
Hold that objection?
Yeah, maybe that second objection is better suited for when we get to
If you get there, we
a
can.
rebuttal case. Yeah,
Right.
but we understand that, but I think the first objection is what we should rule on. Counsel, or anything further?
Well, the only thing I'd like to say is, counsel cited a case called Negrella versus Village of Kildare, which I believe that the board now has copies of. And I would move that all reference to that case be stricken. Did you give them a copy?
Not yet.
Not yet?
Copied up, yeah.
Okay. That case states right on the text of it, this order is not precedential and is not to be cited. And you can't cite an order that says it's not to be cited.
It's the Rule 23 case.
Yes, Rule 23 order, that's exactly what it is, yes. Now, and I also believe that that case is the opposite of this case. In that case, the circulator did state that he was signing it under oath, but the notary failed to affix her seal to it. The difference here is we have notary affixing her seal, but nowhere is it stated in the petition as filed that this statement was made under oath. That's the opposite.
Okay, well, I guess we're still in the objection. Our Gelly case really isn't before us right now as an objection or as a comment.
I didn't want the board to feel that that case made these affidavits relevant, because to the contrary, it's the exact opposite.
We haven't gotten it. We've heard your objection. Now it's the respondent's opportunity to address your objection.
As to the objection, it's clear that the board's own rules allow for the submission of affidavits. This is a question of fact as to whether or not the statements made therein were under oath, or whether they were sworn to in the language of section 10-4. It would be error not to admit those.
Any comments, questions?
I suppose it supports what's already been presented.
It's going to support the respondent's arguments. It's my belief with respect to the objection that even considering the affidavits, we're not in any way reforming the petition, or an affidavit just fleshes out the facts further. It's his evidence as if you were bringing somebody live. You just don't have the opportunity to cross-examine that person.
I waived that objection. We're not asserting. We're not asserting that it can't be done in terms of a live testimony. But if a live witness were here saying these signatures were done under oath, but it was a secret oath that was not revealed in the documents filed with the petition, I would be objecting just as much to the live testimony as I am to these affidavits. A secret oath does not comply with the election code, and this is a secret oath.
I mean, to that point, that is not secret at all. The only question here is whether it was sworn to. Their objection is that it's not listed in the document. Many courts, including not just the Agrella, but other courts, have allowed for parole evidence to prove the very point that stands for, which is that it was sworn to.
And I think that's the essence of his case, correct?
Well, counsel and I are citing the same authority. We both are looking at the IICLE election law book, and there's not one case where they've ever allowed outside testimony. I challenge counsel at the time, one case where they've allowed outside testimony to say that the statement was made under oath. There are definitely cases where the statement said it was under oath, but it wasn't notarized correctly, where they've allowed testimony, as they did in Agrella, as to why the notary didn't sign it. And the concept known as the de facto notary doctrine, but there is no de facto oath doctrine. And there's no authority for that
Well,
proposition.
is there any authority for your proposition?
Yes, section 10-4.
Well, I mean, no, case authority, other than the statute.
Well, I cited Jones versus Dodendorf.
And I guess what I'm asking specifically with respect to this objection on the affidavits and whether we have latitude to admit or not admit parole evidence. You said there was no authority that would permit that, I believe you said.
That's correct.
Okay, any authority that would,
Yes, section 10-4, where it says, a petition when presented or filed shall not be withdrawn, altered, or added to. That's exactly contrary to to allowing the affidavit. It's something that should have been in the original petition and it wasn't. It's adding to the original petition to do it now.
isn't this what these hearings are all about, is to contest whether they were under oath? And
Nope.
isn't that the issue in this case?
No, the issue is whether
the circulator was under oath and sworn to these petitions at the time. Isn't
So
that the issue?
that's what the candidates would like to make this about, but in fact, it's about whether or not the petition is filed.
Sorry about that.
Is this not a meeting?
Well,
But it's not.
there was a little bit of interruption when you were speaking, so they can come in, it's not live.
It's not-
There's a sign out there, isn't it, posted?
Yeah, it's not locked, so.
Okay. Sorry.
That's okay. No, the question in this case is whether the petition as filed meets the requirements of section 10-4 of the election code. One cannot come in later and say, oh, I had more signatures, but I didn't file them at the time, or I had a statement of candidacy, but I didn't file it at the time, or I had a statement of economic interest, but I didn't file it at the time. And you can't say, I was under oath, but I didn't file it at the time, but now here's my oath. And then now that you caught me on this, I'm bringing it in. And like I said, this is not a technicality. The notary is a technicality. Whether or not a notary signs the petition is a technicality because, and this is the de facto notary doctrine, if a person believes he's signing under oath when he signs, and if he says I'm saying this under oath, then defects in the notary can be forgiven because the notary is a functionary not under the control of the candidate. But when the circulator does not state that these statements are made under oath, that is a fatal flaw. And as I say, you could not get a perjury conviction on this based on bringing in a notary who says, oh yeah, that was under oath. He didn't mention it, but it was under oath.
I'd submit that you can obviously secure a perjury conviction based upon a verbal oath that is administered to a person who then signs it under oath, and if it's false. So by that standard, clearly it's met by the fact of it being sworn to. However, the additional statement that this is an automatic is belied by the fact that electoral boards and courts around the state actually do consider parole evidence as to this question. And in these cases, there's absolutely no authority for that assertion, first of all. But second of all, cases in which notary signings have not been signed at all. So here the objection is that the notary signed it, but it didn't include the words subscribed and sworn to before me. That's the only thing that's missing. That is the only issue in this case, is whether those words need to be on this petition sheet or whether the fact contained in the statute as to whether or not the statement was sworn to. That's the ultimate fact. So there's no authority for concluding that the absence of these words is fatal in any way. And I think we can expedite this if council's willing to stipulate that the affidavits and ultimately the testimony of all the circulators who are here, they all say that each of these individuals, and they all will say that each of these individuals was sworn to, they were under oath, they did understand that what they were saying bound them under penalty of perjury, which is the only element that goes to sworn to, which is the language in the statute. So that's the entire case. And if we can stipulate to that and just determine this on the legal issue, I think that's dispositive.
That is a legal issue. One cannot supplement the petition. And I wouldn't say it's the only issue, but it is the issue that the board must decide in determining whether or not to admit these affidavits in evidence. And to decide that one can supplement the record is to violate section 10-4.
And you don't have any case law authority to support that proposition that admission of exhibits to clarify the petition and the oath that's being taken and somebody's swearing to that is in effect reforming the petition as you suggest. I'm just trying to hang my hat on some case authority, and I understand.
To the best of my research, and I looked at annotations under section 10-4, I looked at the IICLE book, council has been making statements that are not supported by any authority. There is no authority saying the oath can be supplied by an outside party. The notarization can be corrected by an outside party, but not the oath itself.
But there's no case law supporting your position that prohibits this sort of testimony.
When there's a statute, I don't think there needs to be any, but no, I'm not aware of any
Okay,
reported
that was
cases.
my only question.
for that.
Right, okay.
Do you have any any statutory, case law authority on this language that the petition, when presented, shall not be withdrawn, altered, or added to? Do you have any, did anybody find any case law on how that's been interpreted?
But let me just state that that goes to when this was, days or weeks or months ago presented or filed, not at this time. We're to rule on the validity of it, not trying to reform it.
Well, I think that is what the council's trying to do, is to reform it, because he was missing an essential element. As I say, he did not state anywhere in the petition as filed. To answer the board member's question, I've seen the statute quoted repeatedly. It's quoted in Jones versus Dodendorf. It's quoted in the other case that I set up for the board, Bacon versus Williams. And it's quoted in the Wolin versus Jacoby case, but they don't, I have yet to find a case in which a party attempted to bring in the element of the oath where it was not stated in the petition as filed. And like I said, it's the same as trying to bring in the statement of candidacy or trying to bring in the statement of economic interests. If it wasn't there when it's filed, you can't come in with a vote.
If either one of you have any case law on the sufficiency of the notary, I mean, the sufficiency of the seal, the date, and the signature of the notary?
It's not the notary, it's a statement that's notarized.
And that's exactly the issue. This is, there's no oath missing from the documents because there's no oath required to be on the documents. The documents are not being supplemented in that sense. We're not adding signatures. We're not adding a statement of candidacy. This is simply evidence as to whether or not the statute was complied with as to the requirement that it be sworn to. And this has been allowed by other boards. So, as to the question of the sufficiency of a notary statement or even of a swearing, I actually, this, not surprisingly, has not been considered too often because it is so basic. There are two cases which I've had copies made. I'll have to tender them. One is it's Cox versus Stern from 1897, which specifically held that parole evidence would be considered. We are of the opinion that the jurat or certificate of the officer administering the oath is not a necessary part of the affidavit, but that it may be shown that the statements contained in the instrument were in truth and fact made as purported to be on oath duly administered by an officer duly authorized. So since 1897, that's been good law. There's also a 1962 case called Rice versus, In re Rice. The site is 35 Hillap 2nd, 79, a 4th District case, in which petitions on public question were considered. Its 3 circulators were accused of not having sworn under oath before notary public, and the court found. The court heard evidence on the question, first of all, so to address whether parole evidence is admissible on this question, obviously that was done in that case, but also they found that the evidence here showed that in every case the affiants approached a notary, asked the notary to take some official action in regard to the affidavits. The usual word used was notarized, which to the layman is the only function a notary public performs. It also showed in every case the notary asked the layman to sign the affidavit, and in some cases the notary asked the affiant to affirm the truth of the matter stated in the affidavit. And in every case the affiant would sign the affidavit in the presence of the notary, and when asked would affirm the truth of its contents. This evidence, in our judgment, constitutes a sufficient basis upon which to support the finding that a sufficient oath was administered. So I think these questions are really fundamental and basic and common sense. So there is authority. I have copies of it, and I just need to collate it and present it.
All right, and you had a chance to read those?
I've read those 2 cases,
Okay.
and let me point out why they stand for the exact opposite proposition. Cox versus Stern, which is the 1897 case, the statement that was notarized said, we, Henry L. Williams, attorney for Ferdinand Stern of Cook County, state of Illinois, and Henry Schoenfeld and Bessie Schoenfeld of Morgan County, state of Illinois, being duly sworn, each for himself and herself says that, etc. And then it goes on to say, subscribed and sworn to by the said Henry L. Williams before me this 25th day of March, AD 1895, and subscribed and sworn to by said Henry Schoenfeld and Bessie Schoenfeld before me this blank day of March, 1895. So both of those, the statement was, I'm saying this under oath. In the 1962 case that counsel cited, in Ray Rice, this here, let's see now, I'm looking for they refer to the Dalby Brothers lumber case. On the first page it started, I blank on oath depose and say. Then, let's see, the Cincinnati finance case they cited, subscribed and sworn to before me. I haven't read every one of the sites in here, but not one of them says that the affidavit had a certificate that used the words being first duly sworn upon his oath, states. You can't have an oath without saying you have an oath. And if you can say it but not file it, then you can sign a statement of candidacy and not file it. You can sign a statement of economic interest and not file it. None of these cases deals with the mandatory requirement of section 10-4. And I don't want to belabor it, but I will just say, read the two parts together, where it says, such statements shall be sworn to before some officer authorized to administer oaths in this state, and then a petition when presented or filed shall not be withdrawn, altered, or added to. It's a mandatory requirement. It's totally missing from the petition. The affidavit should not be amended.
That's a good one. We've had a chance to discuss this briefly, and we're able to roll the objection. Subject to cross-examination or further argument of counsel. I know there's not a live witness, but the rules that we have adopted for this hearing, paragraph 10 do provide that reliable affidavits or other documentary evidence can be considered. So we'll consider them and admit them for that purpose.
I accept the ruling of the board. I would say the fact that they come into evidence does not mean that they change the substantive law, and I hope the board will consider in deciding the objection. We'll still consider the issue of whether or not the candidate can supplement his petition.
Well, the evidence, the affidavit says, once we get into them factually, we'll go to the weight.
Right.
And certainly aren't going to contradict any statute or
Thank you.
statute that you're referring to, so we'll have to take that all into consideration. Thank you. All right, so we've got past the objection. The response group exhibit 1 will be submitted.
Thank you. At this time, I would call as our first witness Douglas Raoul Williams.
Solemnly swear the testimony you're about to give is positive, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, please state your name for the record.
Douglas Rowe Williams?
And you were the candidate in question in this proceeding.
Yes.
And did you in fact circulate some of the petition pages for your own nomination?
Yes.
And were those pages 14 through 21 and 31 through 34?
Yes.
Let me ask you, where did you obtain the forms to be used for these petition sheets?
Right here at the township.
And from whom did you obtain them?
From David McCartan, who's the village, the township administrator.
And were the petition sheets that you submitted as part of your nomination packet on those forms?
Yes.
Did you alter those forms in any way aside from adding your name, address, phone number, and the office sought at the top? All right, now did those forms include any lines at the bottom indicating language such as sworn to and subscribed before me on date with appropriate blanks and a signature line?
I would object based on relevance.
There's an additional estoppel argument here to be made, so we're showing that the forms provided by the township in fact did not include the standard format, the juret that is being complained about in this instance.
Well, I think he's already testified to that, so objections overruled.
Did you in fact rely upon the presentation of these documents by the township?
I'm going to object. The law is the law, and ignorance of the law is no excuse.
The objection as to legal conclusion is sustained.
Did you believe that these forms were valid because they were provided to you by the township?
Same objection.
That's his personal opinion.
It's a legal conclusion.
And then from those forms, did you make copies?
Yes.
All right, and did those copies copy the entirety of the document that you were provided?
Yeah, they were on legal size, so we copied legal size.
And did you provide these forms to any other candidates?
Yeah, the whole team that we ran.
Does that include James Denham?
Yes.
All right, when you circulated the petitions that you circulated, did you personally witness the signatures of the people signing in the lines 1 through 15 of each of those sheets?
Objection. There's no issue as to that question.
Counsel, is this an issue?
No, it's just, this is what he is sworn to. This is what he's under oath.
Yeah, I don't see harm in it. You can test, you can answer.
Yeah, because we had to get a minimum of 349 signatures, we asked everybody to sign 6 times, so yes.
So you mean when you carried your own petition sheets, you
Yes.
carried for 5 other candidates as well?
Yeah, we all did, yes.
So you would sit there and have the person sign your sheet and then each of the others' petition sheets for each of the other candidates?
Yes.
All right, now when you ultimately finished circulating Did you go and get some of these sheets notarized?
Yes.
All right, now, among these sheets, some pages 14, 15, 16, 17, 18, 19, 20, and 21 appear to contain the notary certificate of Alicia Boley, B-O-L-E-Y.
From the Brown Lake Area Library.
And did you appear before her, before signing each of these documents?
Yes.
And she's a library employee?
Yes.
All right. And when you appeared before her, did you get sworn under oath to the truth of what was contained in this affidavit at the bottom of these sheets?
Objection, calls for a conclusion, not the actual statement of what was said.
Did you believe yourself to be under oath at the time you signed those documents?
Objection, there's been no foundation for that question.
All right, did you appear in front of Alicia Boley on December 23rd?
Yes.
Okay, and
It was actually my birthday, so yeah, the 22nd. Yes.
so did Alicia Boley, was it your understanding Alicia Boley was a notary public authorized in Illinois to administer an oath?
Yes.
And did she administer such an oath to you?
Objection, again, calls for a conclusion as opposed to the statement of what was actually said.
This is a,
So,
I think that's, I'm going to deny the objection subject to
I'd
cross-examination.
say it's also a leading question. I think it needs to be asked in a direct examination, you'd be asked in a direct way.
That's true, I'll sustain on those grounds. But, we have to get a little latitude so we can get through this, otherwise we'll be asking a lot of contradictory questions for something which I think is kind of obvious. But it's leading up to the ultimate issue, which isn't so obvious.
Well, for reasons like that, I don't think that's at all. Go ahead.
No, the ultimate, just so we're clear, the ultimate issue of the case isn't obvious because we're listening to testimony now, but where he's going is pretty clear.
Oh,
Well, you can cross-examination, you can cross it.
All right, Mr. Williams, when you appeared in front of Alicia Boley, did you swear that that what you were signing was true?
First she
That's
asked,
it? Okay.
Objection or no?
No objection.
Okay.
first she asked me for my ID, to prove my identity, and then she said, if you are Douglas Raoul Williams, and you're the circulator of this petition. Yes, I am.
Okay, and did you give her your driver's license?
Yes.
And did she administer any form of an oath saying you attest to, or certify, or affirm, or swear, or any language like that?
Objection, leading.
Sustained.
What, if anything, happened next?
She said, you're stating that you're the circulator of this petition and you circulate this petition. I said, yes.
Was it your understanding that you were under oath?
Objection. Third time it's been asked, third time I've objected to it. And it's been twice before.
And again, his understanding is perfectly relevant, and the understanding of the circulators as to whether or not they were bound under oath and subject to perjury if the oath was false has been admitted by courts and by electoral boards as pertinent to the question as to whether or not the oath was sworn to by a circulator. So I don't know any other way to do it, and I don't think that denying this admission, I believe it to be an error that goes to the fundamental issue in this case as to whether or not this was sworn to.
There's been, when I asked what was said, witness's testimony is very clear, I'm not going to repeat it, but there's no testimony that would support his belief, if he had one, that he was under oath.
Well, except for the affidavit that's now been admitted into evidence.
That affidavit does not, that's conclusory. I'll object to that affidavit.
take a look at the authority that you're citing in response to the objection?
Certainly.
Counsel, which case is this?
Agrella?
No, I object. Agrella is the case that said it can't be cited. I object to this being even reviewed by the board.
I'm not gonna look at it. Is there any precedent for us to refer to a Rule 23 order? 'Cause I'm not aware of that. I know we can refer to board elections, and certainly authority that's permissible to review, but a Rule 23 order is not precedential. It could be persuasive though, I think. But
Well, I'm not citing it as binding. I think the board's entitled to rely on even the ICL, which is certainly not precedent, to guide its decisions and to comply with the law. And I don't see anything wrong with a board, an electoral board, considering such authority.
Well, ICL's different. They don't come up with their own opinions. It's based on statutory authority as well as case authority, and they just kind of summarize it for us. But do you need to look at that decision? They've been conscious of that.
Yeah, and let's go back to that, just,
Well, let's go back to the question that was
Right.
asked in objection, so we're getting far afield here a little bit.
right.
The question was whether.
I'm just
whether-
gonna have her read it back,
Oh,
so
okay, good, thank you.
just so we
Yeah,
get
good,
there.
good.
Everybody's on the same page.
All right, was it your understanding that you were under oath?
Okay, and I think we did
Yes.
sustain those objections before, so that objection will be sustained again.
I'm sorry, what's in the basis being that
So
oath
it's
is
a legal
illegal?
conclusion. I mean, there's testimony you can elicit, I'm not gonna tell you how to do it, as to what the facts are, and you've gotten us partway there, but the objection is sustainable.
All right, submit to the board also the In re Rice case is further authority to the admission of not just the previous question, but the entire subject matter. In Rice, if you look at the first page, the bottom left, first column, on the question presented before that court, which was that they were not executed in conformity because they were not sworn to, paragraph A. The court then on page, beginning on page of the opinion, it's 744, continuing for another 2 pages, there's extensive discussion of the circulator's testimony. One of the circulators, Thora Swafford, said that Notary Lewis looked the petition over and asked if she would swear if it was legal, and that she would. Another circulator, Robert Sparks, said he signed under oath, that's a direct quote, as administered by Notary Public Lewis, and that his conscience charged him with the duty to tell the truth. And there are other examples as well of the circulator testifying to whether they felt themselves bound and whether they were answering truthfully. And all that goes to whether or not that constituted sufficient compliance with the swearing that was required in that case. And again, the principle elucidated in that case is that, statutory formalities and the technical aspects of this are not what's important. What's ultimately important is whether these people are sworn to or under oath. So the court found that these instances constituted sufficient swearing. It actually quoted from a whole broad range of cases in other states as well on the same question, which is that where the affiant believes himself to be under oath, is telling the truth, is affirming, that trumps the technical language of what is in that oath, whether someone says it's before an ever-living God, which I think was one of the questions in that, whether they raised their right hand, etc. It's the substance of the statement that they are swearing to, and that they believe themselves to be bound by it, under penalty of perjury.
Yeah, I would agree that the facts leading to that conclusion of whether one is under oath is relevant, and that's what we're here to listen to, but the actual conclusion made by a witness doesn't tell us anything, because we haven't understood what he understands an oath or being sworn to means. And one of these cases talks about, as you point out, putting your right hand in the Bible, et cetera, et cetera. So there's all sorts of specifics. So I think, the objection is sustained, and that's where we last left it. Okay.
Have you signed documents under oath before?
Oh my God, yes.
All right, can you give us some examples of what those documents were?
Objection, relevance.
Well, doesn't that go to the whole issue of whether he understands what he's doing is swearing under oath or not? And it's foundational, which
Okay,
you
I'll withdraw the
objected to
objection.
before, so we're trying to get to it. And
I'll withdraw the
versus a
objection.
conclusory rush to judgment, we're trying to get the facts surrounding it now, so we'll
I'm an insurance broker, so I have a state of Illinois insurance license, so anytime anybody tells me I have to have something notarized, I understand that it's under an oath and a penalty. I can have my license pulled. So I take any notary very seriously, and I do understand that that's putting my reputation and oath before me, so yes, I have done it before.
What type of documents have you executed previously? Not this one, but in other circumstances where you were under oath?
Well, you have to get, what's a good example? Whether it's, if they're bringing, for example, if they're giving me a document that states that, in writing, that it had no losses, is a good example. Okay, so I'm actually attesting to the fact that I received that document from the client, and I'm submitting it to the insurance company under penalty of perjury, that I saw the document, accepted it, and submitted it.
So you know what it means to be under oath in circumstances like that?
Yes.
Have you done that in election capacity before, such as this, previously?
You mean, have I run before?
Have you run before? Have you circulated petitions on anybody else's behalf before?
Yes, for other people, yes.
And what did you understand was happening when you would sign in a notary's presence when you're presenting petitions on behalf of a candidate, whether it's yourself or somebody else?
That I'm attesting by law that I'm the person that's circulating them, and no one else, because those signatures were the ones that I collected personally, and that I meet the requirements of being able to circulate that petition.
Is that what you did here?
Yes, sir.
Yeah, thanks. Okay.
Did you understand whether or not you were attesting to the language contained in the paragraph above your signature on each of the pages contained within your petition for nomination?
Yes.
All right, and when you presented this to Alicia Bowley, did you sign in her presence?
Yes.
As far as your understanding of what an oath constitutes, do you have an understanding as to what the criminal statutes might be concerning that?
Objection, legal conclusion.
Well, again, it's based on his impression of what he's doing, so that's legitimate.
Well, but if you lie, you can be criminally liable, so you shouldn't be, in this case, circulating something if you weren't circulating.
No further.
Cross.
Okay, does Mr. Williams have the exhibit for the petition? Okay, Mr. Williams, let me ask you to turn to page 31 of that petition.
Okay.
You signed that page, did you not?
Yes.
And above your signature, can you please read the 2 lines before your signature?
State of Illinois, County of Lake, sworn and subscribed before a meeting as 24th of December, 2012 by Douglas R. Williams.
Thank you. And the same language is on page 32, page 33,
Yes.
page 34. That's it, right?
Yes.
Okay. You did not print that language on page 14, did you?
No, and I didn't print that other language either, that was the notary.
Okay.
Okay.
By the way, is there a date on page 14?
No.
And I asked you the same questions about page 15, page 16, page 17, page 18, page 19, page 20, and page 21. Would your answers be the same, meaning that there is no similar language and there's no date?
Yes.
Okay, thank you. No further questions for this witness.
Yeah, as to pages 30 through 34, I'm sorry, 28 through 34. Those were in front of Myrna Lopez, M-I-R-N-A Lopez.
Right at Chase Bank.
Just for clarification, 28 through 30 are not signed by Mr. Williams.
Oh, I'm sorry, you're right. 31 through 34, correct?
Yes.
All right, so when you appeared in front of Myrna Lopez, did you do or say anything different from when you appeared in front of Alicia Bowling? Nothing further.
Nothing further. No.
All right, when you appeared before Alicia Bowley and you presented petitions to her,
Yes.
what happened? What did she say?
Well, first of all, she has to ask who I am, so she asked me for my ID, even though I do no work from the library. She said, you know, do you affirm that you are the circulator of this petition? Yes.
That was it?
Yeah.
That's the extent of the conversation. Okay.
May I recross page on it?
Sure.
Did she use the word affirm?
Yes.
Nothing further.
Not from this witness. Is everybody want this here?
Yes.
Erica?
You solemnly swear the testimony about to give this cause to be the truth, the whole truth, and nothing but the truth.
Ms. Lopez, please state your full name for the record.
Erica J. Lopez.
And did you circulate some petitions on behalf of Doug Williams, Douglas Raoul Williams, for his candidacy for township supervisor?
Yes, ma'am.
Okay, and I'm gonna hand you petition sheets 1 and 2. Do those contain your name and signature?
Correct.
And did you in fact circulate those 2 petition sheets?
Correct.
And when you went around, did you use a form that was provided to you by Mr. Williams?
Yes, correct.
All right, did you also circulate for other candidates at the
Yes.
same time?
Same form, we had sheets for every single one of them, so when I was collecting the signature, I was just having them.
I'm sorry.
Okay. Did you hear that?
I didn't hear that. I'm sorry.
Oh, I
No, I'm
was,
sorry, why don't we, you want them to look toward you, so you
That would be
can,
great, thank you.
yeah, I think sometimes you do that, it's a little easier, so why don't we, Mr. Kenneth, if we can switch she's
Yeah,
facing.
here, you want to move it? You can move it back a little bit, so much sense. Did you need her to repeat that?
Yes, I did circulate it for other candidates as well. When I was getting one person to sign the one, they were signing for each one.
All right, and when you finished circulating, did you bring these before Anita Langley?
Yes.
All right, and who's Anita Langley?
She's an assistant manager for Fifth Third Bank.
When you appeared before her, what did you do?
I stated that I needed to get some documents notarized. She asked for my name and said, what am I notarizing? I said, a document that I'm just stating that I circulated for these and saw these individuals sign. So she said, did you? I said, yes, and she signed it.
Did you have any understanding as to whether or not you were bound by that statement?
Objection, call for a legal conclusion.
Stay.
What was your understanding as to what it is that you were doing in seeking notary?
That I'm swearing that I did in fact witness those signatures being signed by those individuals. That I'm swearing that is true.
Okay, did you appear in front of Ms. Langley on December 24th, 2012?
Correct.
All right, and did she witness your signature?
Yes.
Are you yourself a notary?
Yes, I am.
Do you have some understanding as to what a notary's responsibilities are?
Correct.
What's your understanding of what it means to be under oath?
Objection, that is a quick change there. There's no issue here about the notary's obligation, and asking what it means to be under oath is a legal conclusion.
Well, she's a notary, so she must hopefully know what she's doing. She's just going to testify what her understanding of being a notary is. As I understand the question?
Yeah, the issue isn't what the notary did. The issue is what she did, and I think we need facts about what she did, not what's in her head.
Well, I'm confused on objection. Is it relevance?
It's a legal conclusion. It's called that. What's your understanding of what it means to be under oath is a legal conclusion.
It's her understanding of what being under oath means. That's her understanding, her opinion. It doesn't ask for a legal conclusion, so we'll rule on that basis.
Yes, I do understand. My understanding is you're swearing, you're confirming that the statement or the questions being asked of you are true, and if you're attesting to something that isn't, could lead to criminal charges or any further disciplinary action by law.
Okay. And is the statement that you signed at the bottom of each of these sheets in fact true?
Yes.
Nothing further?
Ms. Lopez, when you met with Ms. Langley, did she use the word swear?
No.
Did you use the word swear?
No.
No further questions.
Nothing further.
Unless we have further questions.
The next call, James Denomey.
Sounds right. Hopefully that's what it's called, the truth, the whole truth.
Okay, Mr. Denomey, please state and spell your full name.
James P. Denomey,
Okay.
D-E, capital N-O-M-I-E.
And did you circulate petitions for Douglas Rowell Williams in this instance?
Yes,
All right, I'm showing you pages 3, 4, 5, 6, and 7. Do those sheets contain your name and your signature?
yes,
All right, and are those true and accurate copies of the actual sheets you circulated?
yes,
All right, and is the statement contained at the bottom, a statement that that you believe to be true at the time you signed it?
Yes,
Right. Did you at some point appear before Alicia Bowley to sign page number 3?
yes.
Okay. And do you recall what you had said to her and what she had said to you at the time?
Yes, I asked her to perform a notary public service. She asked for my identification. She asked what these were. I explained to her what they were. And I provided her with my Illinois driver's license. I provided her with more information, gave her my Chippewa tribal identification card. I'm a citizen of the Chippewa Nation as well. So there was no question about who I was, where I'm from, and what these were all about.
All right, and what did she do after that?
She asked me to affirm that, in fact, that this was who I was, what this was for, and what these signatures were about.
All right, and did you have any understanding as to whether or not you were bound by that statement?
Yeah, I sure did. I'm a past commissioner with the city of Milwaukee, the Civil Service Commission, and on the Board of Zoning Appeals, and frequently had to swear in the past, so I had a real good understanding of the truthfulness of my comments and any repercussions that might come about if they weren't true. So, good understanding.
Did you sign at the bottom of page 3 in the presence of Alicia Bowley?
Yes.
Okay, moving on to pages 4, 5, 6, and 7. Were those pages presented to Erica Lopez?
Yes.
All right, and when did you appear in front of Erica Lopez?
I don't have the date, December 20th.
Okay, and what did you say to her, and what did she say to you?
Pretty much the same thing with Alicia Bowley. It's pretty much a repeat performance. We went through the same thing. I asked her to perform the service. I showed her my identification. We did affirm, that was the language used. And we did talk about what this was about. So we both had a good understanding. I had a good understanding of the truthfulness of my comments and what might happen if they weren't.
Did you believe yourself to be bound by what you had signed?
Yes, absolutely.
Okay. Nothing further.
Okay, Mr. Denomi, you turn your attention to page 3. You see the line where your name is printed?
Yes,
And to the right of that, you see the words "do hereby certify"?
yes.
Now, do you see anywhere in this paragraph that it refers to your swearing to anything?
No,
And do you see anywhere where it says you're affirming anything?
no.
Now, you said that when you met with Ms. Bowley, did she use the word affirm or did you use the word affirm?
I think we both did.
Okay. Was anybody else present?
It was in the library, Round Lake Library. There were other people present.
Were they listening, as far as you could tell?
They pretended not to. I think they were aware of what was happening.
Is there anyone other than yourself and Ms. Bowley who could testify that the word affirm was used in your conversation with her?
Good question. I really don't know.
And if I asked you the same questions about pages 4, 5, 6, and 7, well, let me go through all that. You met with Ms. Lopez on December 20th, right?
Mm-hmm.
You didn't say yes for the court reporter.
I'm sorry, yes, sorry.
Okay. And you said it was pretty much a repeat performance. Did she use the word affirm?
Yes,
And did you use the word affirm?
yes,
And was anyone else present?
yes.
Who else was present?
Half the room here.
Okay.
Yeah.
That's fine.
They all heard it.
Was anyone who's not on your slate present?
Yes.
Okay. Who was present other than people on your slate?
That would have been Barbara Jersey.
Okay. And other than those people, is there anybody else in the world who knows that you or Ms. Lopez used the word affirm when you met with her on December 20th?
Let me look around.
And was there?
Yeah, and Richmond.
Okay, so people the people here in the room, other than that, there's nobody else who knows that, right?
No,
Okay. And it wasn't reflected on page 4, page 5, page 6, or page 7, was it?
no.
Thank you. No further questions.
Okay.
No further questions of this witness. Go ahead, Jim.
Thank you. May I have one thing? later.
You can tell me something. All right, our next witness will be Stephen Hall.
You solemnly swear the testimony you have given this cause to be the truth, the whole truth, and nothing but the truth, so help
I
you God.
do.
Okay, Mr. Hall, common spelling Hall.
Yes.
Okay, Mr. Hall, were you also circulating signature pages for Douglas Earl Williams?
Yes.
All right, taking a look at pages 8, 9, and 10. Do those sheets contain your signature?
Yes, they do.
All right, and did your signature, in your understanding, affirm that you were affirming or swearing to the truth of what is contained in the language?
Yes, I certainly.
Object. Well, that's a purely legal conclusion. And it's no foundation.
I circulated these.
Hold on, we got to roll on the objection, sir.
If I can address this, I mean, sworn to, affirm, certified, all of these are things that are part of what he is, and each of these witnesses is attesting to, and their understanding is perfectly admissible as to the solemnity and the truth and the punishment if they are wrong or if they're lying about it. This has been admitted before. This is pure obstruction. The language sworn to is not in and of itself not admissible by these lay witnesses. They can attest to what their understanding was.
If
That's what
counsel-
every one of these questions is, their understanding.
If counsel will stipulate that nothing was said between the notaries and Mr. Hall about swearing or affirming, I'll let him ask that question. However, let's find out what the facts are first.
Well, the facts of what we're here for, and what he said and what was said to him is important.
No, the question was, what does he understand? We haven't heard a word about what was said. It wasn't a question.
Also, objection to foundation then?
Yes.
Okay, this is good.
All right, so when you appeared in front of, let's take Erica Lopez, did you appear in front of her on December 20th?
Yes, at the American Legion.
Okay. What did you say to her and what did she say to you?
Basically, that I showed her my ID, I had circulated these petitions, and that I need them notarized to prove that I, by law, and in case this thing goes to court or whatever, that I did circulate these petitions. I witnessed every person sign and fill out these petitions, and she saw my ID, and she said, okay, and I signed it, and she stamped it and signed it.
All right, did you sign it in front of her?
Yes.
And what was your understanding of what it is that you were saying when you signed it?
That, again, to me, the understanding of a notary is if whatever document is getting notarized, and I've had many mortgages, things like that on my personal nature, when it's notarized, if somebody's contesting it, you're saying that what's on that document is the truth and nothing but the truth. And that's why you get it notarized. So in case it goes to a hearing or a court hearing, my understanding is that, hey, you're telling the truth, that this is what I've done, and I'm not lying about it.
And was your understanding that when you signed it that you were affirming or swearing to
Yes.
the truth of what it was?
Yes.
Objection, calls for a legal conclusion.
He's not rendering a conclusion, it's his understanding.
My understanding is that's the-
Hold on, we got a real objection, sorry, sir.
Sorry.
So, it's this objection.
But that's my understanding, and you get a document notarized, you're saying that what that document states is the truth. And that's why you're doing it, so you can say, hey, judge or honor or whatever, hey, this is what I did is what I did. I'm not lying about it. And that notary is affirming that. That's what I understand.
All right, did you appear in front of Elizabeth Spain to notarize
Yes.
page 8?
Yeah, she's assistant manager of Great Lakes Credit Union around Lake Beach.
All right, what happened during that exchange?
Same thing, I went and I know her on a personal nature. I said, hey, I need this notarized, okay. She said, let's go through procedure. I pulled out my driver's license, she saw it, saw that it was current, and I said, Jack, and I need these notarized, so when we submit them to the township, they know that, that I circulated this petition, or these petitions, and that it's a legal document.
Is your understanding of the effects of this document the same as your understanding of the effects of pages 9 and 10?
Yes.
As to all three of those pages, did you have an understanding as to whether or not you would subject yourself to a charge of perjury if any of the information contained above your signature was false?
Objection, legal conclusion.
Leading, his understanding again is what it is, and he's already testified to that, so.
Okay, nothing further?
No questions for this witness.
Any questions? Here's you, sir. Thank you.
Okay, we would next call Hal Sloan.
Sounds great testimony about to give in this cause, the truth, the whole truth, and nothing but the truth.
I do.
Mr. Sloan, did you circulate petition page 11 on behalf of Douglas Arnold Williams for Avon Township Supervisor?
Yes, I did.
And did you present this to Erica Lopez for notarization on December 20th?
Yes, I did.
And did you sign it in her presence?
Absolutely, yes, I did.
And prior to signing it, what occurred?
I had to bring out my ID, which was my driver's license. Erica verified that it was a valid driver's license, and I signed it, and I signed both my legal name, Harold and Hal. We weren't sure which one would be valid, so we want to make sure that we were covering our bases there. Then she stamped it and signed it herself.
Did she use any words that you can recall as to what you were doing? Or did you use any words as to what it is this document was doing?
I don't recall, but it was generally understood that we were presenting petitions for each other, in this case for Douglas, that were people that we got to sign that particular petition.
Did you have an understanding as to whether or not you were bound by what it is you were signing?
Absolutely.
And was it your understanding that you were affirming or swearing to the truth of what was contained in that paragraph above your signature?
That is correct.
Objection, legal conclusion.
Do you need me to answer that? Okay.
All right, nothing further.
No questions for this witness.
We would next call Ann Richmond.
The sounds great testimony about to give in this cause, the truth, the whole truth, and nothing but the truth. Thank you.
Ms. Richmond, did you circulate petition pages on behalf of Douglas Ronald Williams for Township Supervisor?
I did.
All right, and examining pages 12 and 13, do those pages contain your signature?
You do.
Were those the pages you circulated?
Yes.
And did you at some point, after you circulated them, present them before Jacqueline Hodges?
Yes.
Was that on December 21?
Yes, it was.
Okay, and where did you present them to her?
Jacqueline Hodge is a coworker that I've known for about 4 years. Earlier that week, she had signed and notarized my petitions for candidacy for another office here in the area, and I asked her again to notarize these petitions. I stood and raised my right hand and said, these petitions don't have the same wording that my petitions had, but I swear that these are the petitions that I served to you.
Was it your understanding as to whether or not you were swearing or affirming that what was contained in the paragraph above your signature was true?
Yes.
And what was your understanding of the consequences if it was not?
Could be subject to civil penalties for perjury.
Quick question, Ms. Richmond. You mentioned that you knew that these petitions didn't have the same language as the other documents you had signed? Is
Yes.
that correct? What language was that?
There, on the documents that I had Jacqueline notarized for me earlier in the week, there was language that was already typed onto the form that was given to me by the other municipal entity that included the words subscribed and sworn to me on this blank date of blank 2000 blank.
Thank you. No further questions.
Nothing further. We would next call Robert Flannery.
You solemnly swear the testimony about to give this cause to be the truth, the whole truth, and nothing but the truth.
Yes. Mr. Flannery, are you also known as Bob Flannery?
Yes, sir.
Did you circulate petition pages on behalf of Douglas Earl Williams, your township supervisor?
Yes.
And looking at pages 22, 23, 24, and 25, do those contain your name and signature?
Yes.
And are those, in fact, copies of the sheets you actually passed?
Yes.
In on pages 22, 23, and 24, did you appear before Olga Deitch, D-A-Y-C-H, on December 24?
Yes.
All right, and where was that and what occurred?
That was at the Bank of America branch at Atkinson and 120 in Grays Lake. And I took the sheets that I had circulated to her and asked her to notarize the sheets. She asked me for my driver's license, which I presented. And then she was a little bit confused as far as what she was notarizing, because initially she thought she was notarizing each individual signature. And then I explained to her the language that is written here, that what she is notarizing is that I am stating that I am 18 years of old, and I basically read this paragraph to her, that I was citizen of the United States, and that the signatures on this sheet were signed in my presence not more than 90 days preceding the last day of filing the petitions, and, you know, the rest of the language, so that she understood that what I was stating was that I obtained these signatures under these conditions, and she was notarizing my signature stating that.
Right, did she use any magic words, or did you use any magic words such as affirm or swear?
I'm going to object, it's leading.
I mean, first of all, I would submit that we're not bound by the strict rules of evidence, but second of all, a leading question suggests the answer, such as to say, isn't it true, or isn't this so? I'm asking in an open-ended format whether or not any of these words were used. He's free to say yes or no. It's not a suggested question, but what words were used between the two of you during this encounter?
Just basically repeating what I said before, that I am stating that I collected these signatures under these terms, and that is what I'm signing, and she is notarizing my signature stating that I collected these signatures in accordance with.
Did you have an understanding as to whether or not you were stating, certifying, affirming, or swearing to the truth of that statement?
Compound, leading, and legal conclusions.
It's compound, and I hate to be a technocrat, but he's correct. Can't answer it different way.
What was your understanding as to whether or not you were bound by this statement?
Yeah, I mean, I'm stating that my understanding is in accordance with why you notarize something in the first place, which is you're stating that based on the terms written there, you truthfully, you're abiding by what it says there, for whatever the reasons under the statute, that you have to do certain things and get them notarized for them to be, for the packets to be valid. We understood that we had to collect a certain number of signatures for our petitions to be valid. They had to be notarized in front of a notary for them to be valid. And, that's why we do it, because it's you have to have them.
We're trying to do the right thing, and Illinois has a maddeningly complex and technical election procedure. And it is so easy to make a mistake and so easy to be frustrated in your effort to run for office that I do feel bad for them or anybody else in this situation who tries their best and fails to comply with the requirements of the law. But quite simply, you can't sustain them on the ballot. You can't overrule this objection without gutting the meaning of the word, of the necessity of having an oath, a swear. There simply would be no meaning left to it if you let them stay on the ballot. You have a requirement, mandatory requirement in section 10.4 that it be sworn. You have a mandatory requirement that everything be included in the packet when it's filed.
Oh, I can make it, thank you. I would so move that the objections be overruled on the basis that I stated and for the reasons that Member Goshgarian articulated, and our attorney, Mr. Rock, as well.
So
Second.
if I second it, then we can have discussion, right? All right, then I'll second it, so we can discuss.
We can call roll, can we do,
We can discuss first.
Yeah. Well, I think it's not easy. I think this is not an easy question. And council did a great job. And it's unfortunate that these petitions came out this way. Thank you for pointing out the sincerity and, good intentions of the petitioners. And so I don't find it easy. I don't find this an easy question.
I would agree.
Yeah, I don't find this easy. And, I was listening for statements of whether the affiants, or if that's the right word, whether the circulators were saying that they, were telling the notary that they were swearing this all being true. But I think the Rice case is the one that is the most persuasive to me, because I don't really want to get too, although the trends are important, I don't want to, I'm more comfortable with the law. I think that the Rice case is suggesting that there's a more liberal approach than